Well, it looks like it's 10 o'clock, so I want to go ahead and welcome everyone to this legislative update that's being presented by the Utah League of Cities and Towns. This is the third event of our July 2020 webinar series that's being hosted by the Utah Government Finance Officers Association. I am Kimberly Roosh, the Administrative Services Director for Washington City and the current president for UGFOA. And I'm really grateful to have Victoria and Roger with us today and for the willingness to prepare this presentation. It was one that I know a lot of our members look forward to at our spring conference, and so we're really glad to be able to receive this information now. This session is being recorded and we'll make it available to our members next week on the UGFOA website, along with any slide material. And then we also want to remind you that this training is worth 1 CPE and that there will be 3 polling questions that you'll want to answer and participate in, as well as complete the post-webinar survey so that you can qualify for that CPE certificate that we'll send out. So I'd like to go ahead and introduce our speakers today. We have Victoria Ashby. She's the Director of Government Relations and a proud Cottonwood Heights native. Prior to the League, she worked as Associate General Counsel with the Office of Legislative Research and General Counsel at the Utah Legislature, where she drafted legislation and counseled state lawmakers on public utility, local and state government and education issues. She holds a JD from the University of Utah, a Master's in Professional Communication from Westminster College, and an English degree from the Utah State University. After graduating from USU, she worked as Deputy Press Secretary for US Senator Bob Bennett and hasn't shaken the government and policy bug since. When not advocating for cities and keeping her finger to the political winds, she enjoys reading, painting, traveling to all 50 states, and time with her family. So thank you, Victoria, we welcome you. And then our other speaker we'll have today is Roger Tu, and he has been a fixture, I'm sure many of you know him, on Utah's Capitol Hill over 40 years. He started his career with the Utah State Legislature's professional staff and later served 3 terms as a member of the Utah State Tax Commission. He's worked directly with the Utah League of Cities and Towns for nearly 23 years, and among his assignments are taxation, utilities, and judicial issues. During 2017, he was the acting executive director for the Utah League of Cities and Towns. And Roger has a BA in political science history and a master's in economics from Utah State University and a JD from Brigham Young University. He and his wife Paula have called Centerville home for 40 years. So thank you again, Victoria and Roger, and we'll go ahead and turn the time over to you.
Right, thank you, Kimberly. We really appreciate you inviting us here today. I'm going to drive the presentation. Roger is here as the finance brains. I'm the English major, not the math major. So he's going to give us some information on the tax issues a little bit later on. Let me go ahead and share my screen here. There we go. And I apologize, this is going to feel like death by PowerPoint, but there has been a lot of legislating this year in the last 6 months. So we'll try and get through these, and we're happy to assist as we go along. As she said, I'm Victoria Ashby. I'm here with Roger Tu. I've been with the League for 6 months now, and it's been an interesting 6 months to transition over, but it's been really great getting to know people in the various cities and good staff that supports those cities like all of you around the state. All right, let's get started. I just want to briefly put up the prisms that the League looks at each piece of legislation when we're working during session. We ask ourselves, does the bill respect the traditional role of local government? Is the bill one-size-fits-all approach, or does it really recognize the unique circumstances of each city? And will the bill result in unfunded or unworkable mandates on the city? All right, when we started this session, everyone said this is going to be a quiet year. We don't really see big issues coming on. And we all regret saying that at this point. So you get what you ask for, and that is not what we wanted. Let's start out with land use, which is always a big issue for local government at the legislature. Probably the biggest, most high-profile bill this year was HB 273, Property Rights Ombudsman Amendments. This bill started out as requiring cities or counties to pay damages if a party had gone to the property rights ombudsman for a land use decision and then went to court, and the court agreed with the property ombudsman. Over the course of session, we were able to remove the damages part of that bill. And so the way it works now is if a party receives an advisory opinion from the property rights ombudsman and then further litigates it, they may collect a civil penalty rather than damages of $250 a day. And there was already in code an allowance to get attorney's fees. This penalty is on top of that. What you should be aware of is that the penalty is awarded only if the court finds the opposing party, which in our situation would be the city, knowingly and intentionally violated the law. So there is a high standard that has to be met in order to receive this penalty. Now, to be clear, that the penalty could also be collected from the developer or, you know, the land use applicant.
Victoria.
But it could also be collected from the city. Yeah, go ahead.
I'm sorry, it looks like for us the slides aren't advancing. So we're seeing the slide presentation not in presentation mode. We're seeing it, and so we're just kind of stuck on that very first introduction slide.
Let me, not presentation mode then, okay.
And I don't.
How about I don't do presentation mode? Does that work?
The other thing is, if you do presentation mode, it could just be that window, if you have two monitors, if it's opened up on the other monitor, we're not able to see it. You may have to drag it to the other screen.
Oh, hang on a second. Let's do that. Does that work?
Yes, excellent.
How about that?
Yes, thank you so much.
Sorry about that. Okay, you didn't miss much. Okay, so here we are on 273. And so the key thing to know is that there has to be a knowingly and intentionally violated the law. The penalty is told beginning the later of 30 days after the advisory opinion is delivered or the day that the action is filed in court. Okay, so that was kind of the big battle for us with a bunch of other small battles at the legislature this year. And this is a picture that, just for fun, I've put in here. At the committee hearing about this bill, Representative Peterson, who is there in the blue and white, requested when we got to kind of an agreement position that we post this picture to all our members showing him basically body slamming League Executive Director Cameron Deal. And so that was part of the negotiation, was to display Cameron literally taking one for the team. All right, next piece of legislation is HB 388, Land Use Development and Management Revisions. Each year, the Land Use Task Force, which is an effort by the League, helps facilitate this task force. The members are cities, counties, and then on the other side, members of the Property Rights Coalition, who represent realtors, home builders, developers, have a consensus bill. And so this was that bill this year. It modifies the definition of municipal utility and public easements. It makes more explicit powers and duties of the Planning Commission. It also says that a land use application is submitted to the county, but that property is subsequently annexed during the process. You proceed as if the application was vested from the time it was done with the county. It makes plats voidable only by a land use authority. It makes consistent allowing up to 10 lots without a plat, makes all changes to plat subdivision amendments, and limits right of appeal for adversely affected parties. So if you are involved with land use, this is a bill that you'd want to walk through. We also have HB 29, Building Code Amendments. This bill basically says that if a city or town collects a fee for a building inspection and cannot conduct an inspection within 3 business days after receiving an inspection request, they have to engage an independent inspector. The applicant has to ensure that construction project plans include statements indicating the construction complies with local ordinances, and then there's some other provisions in there adopting parts of the building code as it concerns swimming pools and spas and aircraft hangars. HB 374, Building Regulation Amendments. For some of your colleagues in the plan review offices, they should be collecting this information. We are focusing, the League is helping collect this information from about 82 of the big cities that were subject to SB 34 a couple years ago, the Affordable Housing Bill. But each city is supposed to be collecting this information, and we'll also be sending a survey out to some of the smaller cities and towns on this bill. What the bill says is that the League is going to collect information on the time it takes a city to do a plan review and an inspection. And so under these sections of code, plan reviews are supposed to be done within 14 days for single family plans or 21 days for commercial plans. And so we'll be collecting information to see if cities are really meeting these deadlines. And then same with inspection information, that the inspection has to be prompt. And so we're looking at this information, and then we will be reporting back to the legislature in the fall on this. There was also a moderate income housing element in this bill, allowing an option to reduce building design for single family homes to increase and encourage moderate income housing development. HB 198, eminent domain limitations. This was referenced in Pulsford. This applies to first class counties, so Salt Lake County. It prohibits the eminent domain for a public park established on real property that is a Century Farm located in a first-class county. And then the bill there has the definition of Century Farm. We had another eminent domain bill, SB 205. This is Senator Cullimore. And this bill basically says that if a political subdivision like a city is going in to negotiate real property acquisition, or condemnation in an eminent domain situation, that they negotiate with the fee simple owner. So the best example of this is if you have a strip mall, the city doesn't have to negotiate with each leasee who has a shop in the strip mall. They negotiate with the owner of the strip mall. And that has some other information that has to be given to the property rights ombudsman regarding condemnation actions. HB 305, Urban Development Amendments, and I have a somewhat subliminal message here in my pictures. Representative Perucci was the sponsor of this. So the bill started out with a municipal authority being allowed to charge extraterritorial impact fees for development in neighboring unincorporated counties. So if you're a city and some development starts happening in the county property just outside your boundaries, the original bill would have allowed you to collect impact fees. But the bill was substituted and now prohibits the county from approving an expansion area urban development unless the county notifies and gives the city or town the opportunity to consent to the proposed development. And then there was some notification requirements already for first-class counties that was expanded in the bill. And if you haven't found the subliminal message, this bill relates to the Olympia Hills development out by Harriman in Salt Lake County that's received a lot of news and a lot of public pushback on the development. Inland ports, we saw a couple bills on that. The good news about inland port bills this year is they kind of walked back some of the restrictions that have been in place in the original inland port bills. So some of the political heat had cooled off over the past year or so, and so the legislature walked back some of the things in the original legislation. Primarily, if you're in Salt Lake City, Magna, they added the mayors of those cities to the port boards. The first bill eliminated language related to an agreement for municipality to provide municipal services. It also modified provisions relating to the authority's receipt or use of property tax differential. And then it repeals, this is important, it repeals provisions creating a separate land use appeal authority. This was kind of seen as a huge grab by the state to take this land use appeal authority away from those cities, and it put those abilities back in. And then Senator Escamilla also had a bill that requires the Port Authority to establish a community enhancement program for adjacent communities. So this is kind of to look at the environmental impacts of the port. Many of you know that the inland port is still being litigated. Salt Lake City has sued on the port. They've modified their lawsuit to reflect some of the changes from this session, but that litigation is ongoing. HB 202, Local Government Nuisance Ordinance Reform. This was Representative Moss. If you're in code enforcement, this was kind of a big deal. It's important to read this bill because it's kind of complicated and went through a lot of revisions. But basically what it does is it prohibits a criminal penalty greater than an infraction for any violation pertaining to an individual's pet or use of residence. So kind of think of weeds growing up in your neighbor's yard. Unless the violation amounts to a criminal nuisance, and you need to look at the definition there, and threatens the health, safety, or welfare of an individual or identifiable third party, or the municipality has imposed a fine for a violation on the same person or their pet on 3 previous occasions in the past 12 months. Let's move on to water. HB 226, Stormwater Permitting Amendments. This represents Snyder. The Division of Water Quality is going to adopt rules related to stormwater permitting. Stormwater has been an ongoing issue, and this bill was kind of the result of lots of talks over last interim. The bill says if a stormwater permit is required and a low impact development is utilized, flood control requirements must be reduced by the amount of water retained in the LID. It also creates an appeal process through the Division of Water Quality. And what municipalities should know is that they need to update policies to reflect flood control calculations in relation to a LID under a stormwater permit. HB 96. Oh, go ahead.
On that HB 226, are you seeing anything that you're anticipating coming back for any amendments on that stormwater bill as a result of some of the hardships with trying to implement this at the municipal level? Have you heard anything?
So I don't know of anything official, but part of the land use task force, we have a working group on LIDs this summer. Mark Stratford with Ogden City is leading that group. And if you would like to be part of those discussions, please contact me and I'd be happy to get you in touch with Mark.
Thank you.
Yeah. HB 96, Water Forfeiture Amendments. This represents Ferry. This is mostly a cleanup in the Division of Water Resource Code. It authorizes the division to create rules around a public water supplier's 4-year plan. So if you are interested in this, you might want to engage in the rulemaking process that the division is going through this summer. And then we have a few other water bills. There was a water loss accounting bill by Representative Ballard. It directs the Department of Ag and Natural Resources to create a working group on water loss accounting. HB 166, Watershed Councils. This authorizes the creation of state and regional watershed councils, and we have 1 appointment on that state council. SB 26, Water Banking Amendments from Senator Iwamoto. This was a 10-year pilot project to promote voluntary local water banks and get municipalities to lease portions of its water that it may want to consider a contract bank. And then Senator Andrick ran again a secondary water bill. This exempts secondary water providers in 3rd through 6th class counties from meter requirements on new connections and exempts providers in 1st through 2nd class counties that are unable to get a warranty due to water quality. Okay, annexation. Annexation seems like a really dry, boring topic, but it's one of the most interesting, at least to me personally, and it has become really politically hot this year. So I'm going to walk you through these bills, and if you're completely confused by the end, please email me. I'd be happy to walk through them because there's a lot going on. So first we had Representative Musselman's bill, HB 359. So the first part of this bill permits the municipality in all the class counties except first class to annex an area that leaves an unincorporated island or peninsula. So under the annexation code, leaving islands or peninsulas is frowned upon, but this bill allowed it under these circumstances. If the area is located in the municipality's expansion area and the county agrees, the area is not within another municipality's annexation policy or the municipality agrees, and the annexation is to provide municipal services to the annexed area. So the idea is that everyone comes to the table and they're all in agreement, then you can do this kind of annexation. The other part of the bill permitted an annexation of land in a county of the 2nd through 6th class without the consent of the location count, the county. So let me start over. If you are in County A and you're a city in County A and you want to annex land in County B across the boundary, this was prohibited until this bill was effected. So it allows you to do this annexation without County B's consent and without an annexation petition if the annexation includes property that is owned by a public entity located in a county in which the proposed annexing municipality is located and does not include urban development. Any portion of the real property to be annexed that is not located within the municipality's county is located within 2 miles of the proposed annexing municipality's boundary. So this land has to be close to the municipality and the private real property owner consent. It also clarifies reimbursement provisions when annexation disrupts utility service. So again, this bill allows a municipality in one county to annex land in another county without that other county agreeing to the annexation. But wait, it's going to get special, so just park that thought for a minute. We next have HB 393, Municipal Annexation Amendments by Representative Waldrop. This is dealing with conflicting annexations and incorporation processes happening at the same time. So you may have some landowners in unincorporated county who want to incorporate and make their own city. You might have other landowners that are their neighbors who want to annex into a neighboring city rather than become their own city. So what this said is that you may not include in an annexation petition an area also proposed to be incorporated in a request for a feasibility study if the feasibility study request is filed before the annexation petition and the feasibility study request is still pending. If an unincorporated island or peninsula is within the expansion area of more than one municipality, it has to allow municipality to annex without a petition if both municipalities agree, and then it changes some hearing requirements. But this bill is also about to get special, so just hang with me. During the April special session, SB 3008, which was sponsored by Representative Waldrop, proposed to reverse parts of both HB 359 and HB 393, which were passed at the end of the general session. So here, general session ended in March. We got to April, and the legislature was already changing its mind. But these bills failed, this bill failed in the April special session. So 359 and 393 are still good law. But wait, it's about to get more special. There's been a lot of specialness this spring. In the June special session, SB 5004, Municipal Annexation Amendments, was introduced, and then it was very quickly substituted on the floor. So just as a reminder, HB 393, Municipal Annexation Amendments from general session, struck this language limiting this petition versus to annex versus incorporation restrictions that were just imposed on first class counties, now expanded that to 2nd through 6th class counties. So here comes SB 5004. What this did is that, first of all, this bill doesn't apply to first class counties, but it expanded what had happened during session. What it does is it says that if you have competing incorporation and annexations, it prohibits filing the annexation petition if an incorporation feasibility study request is filed and pending unless an annexation petition is filed on or before August 5th, and notice of intent includes the map, and annexation petition is filed on or after November 15th, 2020. So what the bill did is it created this pocket of time, and if you're looking at that and thinking there's an election in the middle of there, you are correct. And so if you're looking at this and thinking, this seems really like special legislation, you are correct. What the bill did is it also expanded HB 359, and it allowed now these cross-county annexations to create islands or peninsulas. Again, islands and peninsulas are frowned upon in the annexation code, but this bill, this substitute in April, allowed those to be created. So if you are reading the news, you might have come across what's happening in Hideout, in some property in between Hideout and Park City. And Hideout is proposing to annex this land, which reaches across Wasatch County, where Hideout is located, into Summit County. And that is possible because of these bills that were passed in general session and during special session. There's a lot of controversy around it right now, and it's possible that some or parts of these bills will be repealed in another special session, but we'll have to wait and see. Because of all the craziness around annexation, I have given annexation the Frankenweenie Award for this year. When I worked at the legislature, I drafted a bill every year that I found I was sewing dead body parts to make something that was unnatural become law, and deemed them the Frankenweenie bills, and I'm giving annexation the Frankenweenie Award this year. Okay, moving on to housing. All right, housing continues to be a hot topic. It has elements of land use in it. As we try as a state, you know, our housing prices continue to go up, and we're trying to find solutions for encouraging affordable housing. So Senator Andrick ran SB 34 in 2019. Cities, in particular, this list of 82 cities, were expected to put on their master plans an affordable housing component, and thank you to all of the cities who complied. All of them were in compliance at the end of last year, getting the reports in. SB 39 is round 2 of SB 34. So what it did is it created $10 million in one-time funding. That funding goes for gap financing of private bond finance rental housing and other stipulations for housing programs. SB 122, this was referencing kitchen, housing loss mitigation amendments. It requires UDOT to report the number of moderate income housing lost in the previous year to UDOT actions. So if, you know, you're building big intersections or freeways, how that's impacting moderate income housing. And it requires the Commission on Housing Affordability, in consultation with local governments, create recommendations to address those losses. SB 165, Emergency Response Plans for Homelessness. This bill required the Homeless Coordinating Committee to develop with the Council of Governments a non-binding emergency response plan to respond to emergency conditions that pose a risk to homeless individuals and families. Again, these plans are non-binding, but it's encouraging the COGS to get together and put these plans together to address these needs. HB 440, the Homeless Services Funding Amendments Bill. This bill appropriated money to the homeless shelter operators. If you're a city with one of these shelters, you should be receiving some of that money, and then appropriated $75,000 to fund a study through the Gardner Policy Institute to review the state's homeless system governance. SB 244, Homeless Shelter and Service Sharing Amendments from Senator Andrick. This required the Housing Community Development Division to coordinate with the Homeless Coordinating Committee and oversee homeless management information systems, and appropriated $1.5 million for one of these information systems. Moving on to criminal and law enforcement. All right, body cams continue to be a hot topic, and we will probably see more bills on law enforcement during this upcoming session. This bill modifies the list of circumstances in which an officer may deactivate a body-worn camera. It requires a police officer to document reasons why the officer failed to comply with the requirements related to body-worn cameras, and under specified circumstances allows the presiding judge to provide an adverse inference instruction to a jury of a criminal trial if an officer failed to comply with the requirements related to body-worn cameras. So under these limited circumstances, if there's an issue that goes to trial, there can be times where the jury can consider why the officer was not in compliance with the requirements to wear a body camera. HB 298, Victim Guidelines for Prosecutors. This basically enacted guidelines for prosecutors, and it's fairly specific to these Form I-918 Supplement Bs, which is a form that is for people who are not citizens of our country but testify against crimes. So it's trying to encourage them to come forth as witnesses and help law enforcement. It provides uniform guidelines for prosecutors and other entities related to immigration status for a crime victim who provides prosecutorial assistance, and sets up timelines for completion of certain forms. SB 214 deals with gambling. Basically, we already had on the books and in our Constitution that gambling is illegal in our state, but we see various forms of it in these kind of video devices popping up through the state. So Senator May's bill modified the crime of gambling to try and get to these devices. It increased the criminal penalties for an individual convicted of a gambling offense. It prohibits placing fringe gaming machines, which are these video devices, from operating. It also allowed municipalities and counties to seize gambling debts, proceeds, and fringe gaming devices under circumstances, and gave a cause of action to someone who suffered and lost from one of these fringe gaming devices. HB 288, Prosecutor Data Collection Amendments. This is a fairly complicated bill, and so if you're working with prosecutors, you would probably want to get in and review this bill. And I have a note here on the bottom that it should be reviewed in conjunction with SB 193 because the two bills were coordinated together at the end of session, and it kind of changes the substance of the two. But basically, it requires a data collection and reporting to CCJJ 3 times a year on behalf of prosecutors in the courts and jails. And it puts some other requirements on the prosecutor offices that they have to publish by January 1st next year and collect data. So this may create some added expenses for your prosecutors and definitely adds additional requirements that they need to meet. HB 83 expungement amendments. This basically required a prosecutor to notify a victim of an expungement request for a charge dismissed under a plea and abatement. So it's looking at victims' rights who are involved in these kind of criminal prosecutions. And HB 206 bail and pretrial release amendments. This makes multiple changes to the bail and pretrial release process, creates a new court order called pretrial status order, and change some of the charges that you can bring against someone who pleads guilty to charges on a citation. All right, now I've just hit the miscellaneous part, and so I'm going to go through these. I apologize that it's kind of quick, but you're always welcome to go back and look at the presentation and email me if you have any questions. All right, Senator Harper had SB 56. This deals with retirement. It says that a participating employer must make an additional non-elective contribution to an employee that is a member of the Public Safety and Firefighter Tier 2 Defined Contribution Plan. And if a municipality opts to pick up some or even a portion of the Tier 2 public safety, employee portion of the benefit in the hybrid system, the municipality must make the same level of contribution for employees in the defined benefit tier 2 public safety system. Other additional contributions are optional. SB 271 state retirement amendments, the Senator Hemmert, provides that reemployment as a part-time appointed or elected board member is not subject to post-retirement reemployment restrictions under certain circumstances. So if you have someone who previously worked for the city and comes back, this bill changes their status a little bit. It provides that a member is not required, or I'm sorry, I have to take that back. It's not if they come back, it's just if they're part-time appointed or elected. It also provides that a member is not required to cease services as a part-time appointed or elected board member of a participating employer under certain circumstances to be eligible to retire. And so you should look at and update your policies to allow qualifying retirees to serve on boards and commissions. All right, HB 221, municipal office and local elections. This requires elected municipal officer to reside in the district that the officer represents. So my picture of the carpetbagger here, he basically has to vacate his office. And then HB 98, offense against the administration of government amendments. This is a continuation of a bill from a few years ago on the misuse of public property by public employees and officials. The amendment amended the penalties if a public servant misuses public property or money. It's a crime for a public servant to knowingly engage in certain misconduct related to public property, but it did also add a certain uses are de minimis and so not subject to these criminal penalties. Okay, there we go. All right, HB 82, governmental immunity modifications. This says that governmentality, its representative or insurance carrier must inform a claimant under the Governmental Immunity Act that the entity has received a claim. So basically, if you have a claimant that files a claim, that the governmentality has to let them know that they have received that. HB 283, the Outdoor Adventure Commission amendments. This was a bill that was of great interest to Speaker Wilson. And so it created the Outdoor Adventure Commission. They're going to look at outdoor recreation plans. This obviously will affect local communities, either if the commission comes up with certain land use requirements or incentives to create recreation. But we have an appointee on this commission. However, the commission was defunded in the subsequent special session because of COVID. So we're still kind of waiting to see what's going to happen with this commission. HB 280 deals with the TRT, the transient room tax. It modifies how TRT revenues may be used in 4th, 5th, and 6th class counties and in a county where a national park is located. And it changes the reporting requirements and requests additional auditing support. Okay. HB 277, personal delivery device amendments. This is Representative Barlow. For personal delivery devices, remove prohibition on utilizing roads, eliminated weight limits, and increased speed. So if you're wondering what a personal delivery device is, this is it. This picture of one of these little bots going into the committee room. They are not small, but they're the people who want to put these out on the streets felt like there were too many limitations on them. So the bill reduced some of the limitations that local government can put on them. Any regulations the municipality does place on the personal delivery device has to be reasonable. Okay, SCR 6, concurrent resolution for study of local option sales tax. This is where Roger gets his 5 minutes of fame. This was a resolution encouraging us to look at the sales tax changes. Roger, I'm going to hand it over to you to just give following information on what's going on with this.
I might mention, Victoria, apparently the slides are not running. But
Oh, okay. Let me work on that.
Well, while you're doing that, I'll just make a few preliminary comments. Victoria mentioned that the session didn't turn out like we thought it was and everything subsequent to that, and that's true. For me, the last 3 years have been chewed up entirely by one thing called tax reform. And for 3 years, that was the dominant issue on the Hill, the dominant issue for cities. We started off with potential changes to the 50-50 distribution formula that went to a wholly complete change to possibility of taxing services and changing rates. We spent the last 2 summers in constant meetings on that issue, and finally arrived at a point where there was going to be a major tax proposal change, but it would not involve impact cities. So we work, as I tell people, it takes a lot of work to make sure nothing happens. And that's what we had basically accomplished. Then the legislature, in what I will argue was probably an ill-conceived plan, rammed this through in a special session in December of last year. They, however, didn't get a 2/3 vote in that on the passage of that bill, which meant it was subject to a referendum, which I would say most people were totally stunned to see that a citizen group would be put together that fast to get that many signatures to put an item on the ballot. So the first week of the legislative session was to repeal everything that they had been working on for the previous 3 years, which is partially why we felt that the session was going to be a little bit low key for us, because this huge gargantuan activity, which had eaten up all the time, had disappeared. Not knowing that there was going to be an even bigger, huge gargantuan thing occur right after the session. But I think it's important to note that how dominant the discussion of tax reform has been. I might mention that this November had almost no discussion. There's a major constitutional amendment on the ballot to change some of the earmarking of the income tax provisions, and which, if it doesn't pass, everything's back to square one with the legislature on what they were talking about with their tax changes. So I just throw that out there. It doesn't directly involve cities, but it's a huge issue. That having been said, a resolution that Senator Bramble put up early in the session, we spent considerable time dealing with only because of an implied message that it sent, which was that we were committing to looking at a re-examination of the 50-50 distribution formula. For those who may not know, half of the sales tax is collected on your basic 1% that every city in the state levies. Half is given to you by point of sale and half is given by population. And that's been the sort of fairness distribution formula that's existed since 1983. It's been a long, long time, and it's sort of become something that's held the league together to say, hey, we've all bought into this. There may be changes that occur because of economic factors, but we bought into this fairness. It's our money. It's not the legislature's to decide how they want to distribute it. Well, into the mix of this, there have been changes that are occurring, and frankly, you're seeing this now with the COVID situation, that as people buy things online, that the point of sale component of that is not a store. There is no retail outlet you're getting it from. When it's delivered to your doorstep, the point of sale becomes your home. So if on my doorstep in Centerville is the point of sale for that sale, no matter where it comes from, if it's delivered to my house. So it's a slow shift in some measure to an increase in the population component, if that makes sense. So in effect, the point of sale becomes your home, and you're already getting an element of this with population. That's going to happen. There's no argument that that's occurred. In fact, for those who have been critical of the 50-50, we argue you're getting a shift to population anyway, so stop worrying about it. But it's something Senator Bramble wanted us to be aware of, particularly when you start seeing cars and other high expense items could potentially have the point of sale shifted as well. If you're a city that has built your sales tax base around car dealerships, for example, and what is the magnitude associated with if the point of sale component can be shifted? It is not an issue. We're fully aware of it. Frankly, we told Senator Bramble, you don't need the resolution. It's something we'll study anyway. But that's what the resolution in effect does. It does not have a time deadline on it. It does not have a mandatory conclusion, but it was an awareness issue that the entities that receive sales tax who have a large component of that built on point of sale. And I might mention all the other sales tax rates except the 1% are entirely point of sale. We ought to start getting a handle on what the impact may be. What COVID has done is it's probably enhanced the online sales component. And I think if those of you who look at your sales tax distribution information will probably see an increase that's occurred on the amount of unallocated point of sale sales. We're going through a change in the economy. Malls used to be viewed as everybody wanted a mall. I'm not sure that's the case anymore. And so anyway, that's what the purpose of that study is. There wasn't a time frame in it. COVID has eaten up the band space that everybody has. It's something that I'll start putting together some sort of information together. We've been asked to involve UAC, Utah Transit Authority, any entities that levy a sales tax or is levied in their name. So that's the essence of Senator Bramble's resolution. I think Victoria and I will say an enormous amount of time was devoted to making this language outcome neutral. And I give Senator Bramble credit for coming around to saying, I just want you to be encouraged to look at this change that's going to be happening. Message received, and we'll be working on that particular issue. The resolution on construction and demolition, do you want to say anything about that, Victoria?
Yeah, I'm assuming you can see my screen now, hopefully.
Yeah.
Yeah, this resolution is just requiring the league and UAC to get together and put some model ordinances together on demolition waste diversion rates. So we will be working on that over the interim. Okay, and then we've just got our remaining handful of grab bag bills from general session. There was a bill on waste tire recycling amendments and increased the number of whole waste tires from 4 to 12 that you can transfer to a landfill. There was a bill on yurts. This yurt bill took a surprising amount of time, and it only applies in county, unincorporated county, but if you have extraterritorial watershed, you should look at this legislation. There was also a bill on towing. There's almost always a bill on towing. It allows political subdivisions to enforce their parking restrictions on their own property. And it also allows you to request a tow truck to abate a public nuisance on private property within the political subdivision's jurisdiction. SB 169, transportation utility fee. There is some litigation going on about transportation utility fees. The bill was very simple. It deleted the word tax from the definition of transportation utility fee. None of us are really quite sure what the intention was of this or how it would change the litigation. But we do have in Rogers leading up a group on transportation utility fees over this summer. HB 184 allowed municipalities to regulate golf carts, which you could pretty much already do, but now it's clear in code that you can do this. HB 294, mining operations, applies to municipalities with basalt operations. HB 348, business licensing amendments. This allows the municipality to charge an insurance company a business licensing fee. There was a weird old loophole in the code that allowed insurance companies to forego paying a business licensing fee. This closed that loophole. And SB 115, bonding amendments. The lien requirements on political subdivision general obligation bonds and certain requirements on tax levy revenues used for payments of bonds. So it made amendments to some of that language. So session ended, and then COVID hit. On the last day of session was the day of the governor sent out his order that people needed to stay home. And so we entered April with special session, which I call COVID Goes to the Capitol. Basically, as we had legislation on a duel of the branches, the legislature disagreed with how the governor was handling things, so they were also looking at political subdivisions. And so these bills reflect some of those checks and balance fights. Senator Hemmert's bill created the Public Health and Economic Emergency Commission. The commission presented the COVID recovery plan to the governor. And what's important to know about this bill is that if the governor adopts a recommendation made by the commission, that adoption then supersedes any portion of a local ordinance or order that is more restrictive than or in direct conflict with the adopted recommendation unless the governor allows an exception. So right now you are seeing cities or counties who are in the yellow zone under the governor and they feel like they should be in the green zone. They cannot issue their own local orders contrary to what yellow prescribes. They have to go through their local health departments and go up to basically the state level and get permission to alter or be different than what they're currently in. And so when you see some of that, that comes from this bill. SB 3007, this bill created immunity from civil liability for damage or an injury resulting from exposure of an individual to a contagious virus. And person, meaning someone who has that civil liability immunity, includes political subdivisions. Excuse me. It addresses the relationship of immunity to other state or federal laws, and it does not apply to willful misconduct or reckless or intentional infliction of harm. So if in some weird situation, a city intentionally spread COVID to people, they would not have immunity from liability under this bill. Then we had this resolution urging all of you, our state and local governments, to be cautious about your spending. So if you weren't already aware that budgets are tight and the economy is volatile, this resolution made sure that you knew. This bill, HB 3009, I'll just go through quickly. It had a lot of press. It was trying to curb basically county and city mayors' ability to do local orders. So you saw some of the fights with Salt Lake City or Salt Lake County on closing businesses or requiring masks. This bill was trying to get at that. It was also getting at local health department authority. And then it also included, unfortunately, some things that we had requested for. When COVID sprang up, we discovered a lot of statutes are hard to execute when you're trying to do social distancing, offices are closed, you can't access documents if a grandma request comes in. But what happened is that there were some fairly far-right groups who got wind of this bill, honestly read it completely wrong, saw it as an expansion of the government's ability to take away your rights. And so these sort of things were popping up on social media. They inundated the legislature during that special session, and ultimately the bill failed, mostly because of these groups' efforts. The June 5th special session, again, we've had lots of specialness this year. I'll just go through this quickly. Representative Peterson had a resolution which passed, and they extended the declared state of emergency to August 20th. So as far as the state's concerned, we are still under this emergency declaration until August 20th. The legislature could further extend that, and we are hearing rumblings right now of an August special session. One note is that the next date you should be looking at as far as the color guidance for COVID is August 1st. That's when the governor is expected to review the current COVID guidelines and make new determinations. And then HB 5002 from Representative Potter. At the beginning of COVID, the governor issued an executive order allowing government bodies to forego the anchor location requirements in the Open and Public Meetings Act. And this bill basically codifies, for the most part, that executive order. What it does is it says that if the public body chair, so if you're having a council meeting, the chair of your council makes a written determination that holding a meeting by using an anchor location would create a substantial risk to health and safety, that you can forego the anchor location and just hold the meeting electronically. You have to publish that determination with your notice and also read it at the beginning of the meeting. And it only lasts for 30 days before you have to make that determination again. Otherwise, you have to go back to holding the meeting with the anchor location or just holding it as you regularly would in person. And then during April is when, or excuse me, June is when we had, you know, obviously a lot of the protests about peace officers and law enforcement and excessive force. Representative Holland's bill prohibits peace officer training curriculum from containing instruction on chokeholds or other restraints. It also prohibits training peace officers on use of those types of restraints, and it bans peace officers from using knee on the neck restraints. SB 5006 Public Safety Worker Protection Amendments. This was an attempt to protect workers who might contract COVID. So what it did is expanded an existing statute that if, say, a police officer was trying to arrest someone and that person intentionally spits on or coughs on the officer and that person knows that they have COVID-19, it allows a court to issue a warrant to require that individual to be tested so the officer can know if they've been exposed. And it puts criminal penalties for intentionally exposing public safety workers to a disease. So that wraps up all the sessions. Just quickly, interim issues. Many of you have probably been watching the CARES Act funding. Just as a reminder, this is for non-budgeted necessary expenditures related to COVID. You cannot use these funds to replace revenue. They're being distributed in 3 tranches. The first tranche from the state has already been issued, and there are now talks on the second tranche. We recommend that you review the U.S. Treasury guidance on this. It provides $175 per resident, and the first tranche was distributed based on populations. You can see those distributions there. Whether or not the second and third tranches will be based on population is still going to be determined. And you have to remember that if you misuse these funds, you have to pay it back. You have to indemnify the state or county from that and deal with the Treasury if you misuse these funds. And I've shared a couple links to Kimberly that obviously won't work here on the slides, but the League is collecting how cities are spending these funds and then has a spreadsheet that you can see best practices and how cities are using the CARES Act funding. Roger, I don't know if you want to add anything else on CARES Act.
No, you did a good job. A couple of things I'd add here. Bear in mind, Utah County and Salt Lake County received their own pot of money, and basically part of the difficulty of initially moving on was how they were going to allocate money to the cities in those counties, because the money that came from the state of Utah to the cities did not include the cities in those 2 counties. After some nasty and intense negotiation, basically Utah and Salt Lake County have allocated the money in the same fashion that the state did. But I would say there's going to be a serious discussion about how that money is being used in the first tranche. I don't see Salt Lake and Utah County deviating from the overall plan, assuming we come up with a plan for the second or third tranche. I will say the initial feedback, though, is that it's a lot of money, and the actual direct COVID expenses are proving to be at this point probably less than the money that was been allocated. That's a generalized state. Some cities are clearly going to be different because it's not a revenue replacement, and the big hit economically for most of our cities was the lost sales tax revenue. And so we're going to be having some initial meetings on this, on the second or third tranches. Like I said, everything I've been told says that Salt Lake and Utah County will go along with the decision that's made with the state, but whether it's going to deviate in general from just the third, I don't know. I would assume not, just because it's politically so hard to come up with something else. But it has been a lot of money, and even though there's a lot of need, so much of the need is revenue replacement as opposed to actual COVID expenses. And that's at least sort of the preliminary numbers that are coming back on that regard. one other thing I want to say, only because I know the state auditor is involved with your organization. John Dougal's office was had it in place by the state to sort of look at the overall use of the expenditures. The state auditor does not have an authorizing or approving role on whether the money or not meets proper expenditures. That's entirely the U.S. Treasury that makes that decision. So he's never asserted differently than that. I don't mean to imply that, but I have had that question come up. That was a legislative designated role. Your city's expenditure involvement is with the U.S. Treasury. They're the ones who will make that decision. But that's what that document that you all signed was. If the Treasury deems it an inappropriate use, the state, you're going to have to pay the money back. The state is, or Utah County's not going to pay it back. The city is, or Salt Lake County. So those would just be the basic discussions that I would say on the CARES Act funding. There was one other question that came up while on the transportation utility fee. It's the legislature trying to authorize it. The term legislature is a pretty loose term. I would say a big chunk of the legislature doesn't know anything about it, because we only have a handful of cities that have imposed it, and that's a concentration in Utah County. I would say initially some of the affected legislators, that would have been their goal, but as time has gone on, the dilemma that exists right now is, as the 3rd District Court has said, cities do not have the authority to impose this. So the question is, if you do come up with an alternative, it's going to be a statewide alternative. What's the enthusiasm for, in essence, a new authorization of a new local tax? Those are some of the questions that we've got to talk about. Or is it better course to let the courts take it up on appeal and decide what happens there? So that's a quick answer to that question of what the legislature's involved in.
Roger, it looks like we have one other question, and Roger or Victoria, from Kim Coleman, and he'd asked about the CARES money. Is there any talk about making it available to the special service districts and things like that there?
My understanding it was a cities and counties issue. The question has been applied, could apply to interlocals. The answer is it can apply to interlocals if the decision of the city or a county who's part of that interlocal chooses to use some of their money for the interlocal. But the money was allocated to those two political entities, cities and counties.
Okay, thank you, Roger. This is my last slide, so I'm just going to leave this up. But you are welcome to contact me or Roger if you have any questions, or anyone at the League. These are some of the issues that we are working on over the summer. Some of them, as you can see, CARES Act is on there, as we continue to watch what the feds do with further stimulus packages. Much of them are, some of these issues are land use, some of them are overflow from the session. So we're staying very busy, but if we can assist you with any, or if you're interested in working on any of these issues, let us know, and we would be happy to get back to you. So that is basically, let me make sure, yep. That is basically it, but thank you for having us. Sorry we went a little bit over time and had some technical glitches, but thanks, Kimberly, we appreciate it.
Thank you, Victoria and Roger, for putting this together. We're certainly super appreciative of that. And we want to remind those who are participating that our 4th and final event next week we'll have is an economic update. And we invite all of you to join and participate in that. It's going to be done by Robert Spendlove with Science Bank. And there is also a survey link that will be available at the close of this that you want to fill out if you're needing CPE credit. And then it's also valuable to us to know how to kind of better serve you guys as members as well. So I think that's it. And again, we'll have the slides and the recording posted up on the resources page of the UGFOA website following the compilation of everything. So it should just take a couple of days. So thank you.
Thank you.
Hey, everybody.